All right, let's go back to our leading story where President Cyril Ramaphosa has indeed been granted his urgent interdict against former President Jacob Zuma. And joining us via Zoom is legal analyst, advocate Romeo Nthambeleni. A very good afternoon to you. Thank you so very much for joining us here on SABC News, sir.
Good afternoon, Flo, to you and the viewers.
Let's start here. Your thoughts, please, on today's judgment to grant President Cyril Ramaphosa that urgent application. And on the back of that, how do you believe the president's legal team was able to sort of successfully meet those very straight and strict requirements necessary for an urgent interdict?
Yeah, thank you, for that question, Flo. I think, the agency issue was an important, hurdle that the president legal team had to actually jump, and they successfully have actually done that because the agency was established by the matter that was coming to court on the 19th of January. And on that basis, the court found that there was real agency that had to actually be attended to, and gave the order that the interdict must be granted, and that is part A of the application that the court actually entertained. So I was not actually surprised on that score that the court saw that there was agency in the matter, because those grounds were actually established in the application, in the comprehensive application that the president brought to court.
Yeah. Part A, which was being ruled upon today, focused on whether the president had established urgency, as you say, by showing inter alia absence of alternative appropriate relief. Was the court correct in concluding that there is no alternative relief to the president? Why would there not be any alternative recourse for the president?
Yeah, look, you might look at it in two ways.
Yeah.
In terms of the interim interdict that the court has actually granted, that the court has granted this as an interim relief, not as a final relief, to say that when the court entertains part B of the application, then they will be able to make a determination whether there is merit in the application which the president has actually brought in relation to the interdict.
Yeah.
And now that the president has actually jumped the first hurdle of proving that there is agency in this matter, then the part B will entertain the merits to actually grant him the final relief that he actually seeks, looking at the merits of the requirements of an interdict that he still actually has to prove before the court.
Yeah. And speaking of Part B, wouldn't the court know better how to tackle, or as you say, entertain Part B, knowing how the case against, I'd say the main case against Advocate Billy Down and Karen Moore actually then sort of plays itself out? I mean, this particular court had said, and I'm quoting them here, said that nothing which is stated in this judgment is in any way meant to have any kind of effect on this case.
Yeah, you're absolutely correct. The court did not want to delve into the merits of the Part B of the application. The only thing that they dealt with was to entertain the agency of the application. And the court quoted with authority Solomons, because we must remember, Flo, there was a big debate about whether the court can interdict a summons.
Yeah.
And then the court, citing Solomons, it's a 1950 decision, correctly opined that the court can actually do that. And there's no clear distinction between a criminal court and also a civil court, because the court does that in its allocation of roles. It's still the very same court, and no one can bring a person unfairly to court. And that was the argument that was put forward by the president's legal representatives, to say that his rights are going to be infringed, and then he might actually suffer irreparable harm. Yeah. And the court actually agrees with that, to say that is important, and that is an important determination that has to be given. And that clearly established the grounds of agency that were very important in the matter.
And then I want to talk, Advocate, about the issue of jurisdiction, the issue of jurisdiction, which I think that the respondents' legal team was really sort of, at pains to iron out and want to be heard on. The jurisdiction of this court to consider relief on this matter was indeed in question, and certainly by the respondents. They said that the civil court can't address an issue before a criminal court. That's part of the argument that they had indeed put forward when they were talking about the issue of jurisdiction. Can a civil court in actual actual fact then decide whether someone should stand in a criminal matter? Does that not sort of murky the waters in terms of separating civil and criminal procedure?
Yeah, what is interesting, Flo, there is what the judgment said, and which I actually agree with. The judgment said a court is a court. When you make the distinction between a civil court and a criminal court, it's when you are allocating the matters. And then the most important question which the court answered is whether the High Court has the jurisdiction to actually entertain the application. And they said correct, rightfully so. The High Court has the jurisdiction to to entertain this application on the basis of agents. And whether the issues of criminal and civil court has to actually be dealt with. We'll now have to look at the merits of the case that is being brought by the applicant against the respondent as to whether the court can interfere when the rights of a person are being offended. And the court rightfully said, yes, we have jurisdiction to entertain this matter. And we can clearly make a distinction between what a criminal matter is and what a civil matter is. A criminal matter established under the Criminal Procedure Act and a civil matter. And now, to throw the spanner to the work, the question was the private prosecution that was at play here, because that was the main issue which the court looked at and said, let's make a distinction between a private prosecution and a prosecution that is being brought by the Criminal Procedure Act, by the NPA. Those are two distinct matters.
Are we able to talk about precedent when it comes to the allocation of criminal versus civil matter? I mean, what is the precedence when we're talking about this particular case? Have we seen a situation where a criminal matter has been dealt with by a civil court, or are we entering new terrain? How has this been dealt with before? Has someone who is being criminally charged had the pleasure of having a civil court saying, well, actually, no, you cannot be criminally charged in a criminal court? And why shouldn't there be a distinction? I seem to understand you saying that there shouldn't be a distinction, that a court is a court.
Yeah, this is what the judgment said, to say the court is the court, and the distinction that we make, Flo, is when the matters are being allocated, that criminal matters are obviously allocated to a criminal court, still in the very same court of law. So that was an important determination to actually make, and the court said nothing much turns on the separation between a civil matter and a criminal matter. The question which was supposed to be answered is whether the president came to the right court to actually bring an interdict, and whether the president can interdict criminal proceedings. That is the question that we must actually clear, because there was a debate on whether you can be able to interdict criminal proceedings. And the court said that is very, very much important, because now we are dealing with a private prosecution, and the hands have referenced that case of Solomon's, where the court said that when there is an unfounded private prosecution that has been brought, the court can actually vindicate the rights of a person who is being unfairly dragged to court. And that is the argument which the president has actually brought forward, to say that the former president does not even have the title to prosecute, so he is being unfairly brought in a court. And the court said, yes, under those circumstances, based on Solomon, we can actually interfere. All
right, I think you've ironed it out for us perfectly. Thank you so very much, Advocate. We always appreciate your time here on SABC News, sir. Thank you. All right, there is Advocate Romeo Nthambeleni there, our legal analyst this afternoon, of course, so weighing in on that case that we've all been certainly watching.